me test it. Good morning, everyone. Can I invite you to make your way in and sit down? We're going to be starting at 9 sharp. Sharp. Colleagues, good morning, everybody. Can I ask those who are lurking in the reception area to come in and sit down? We're going to be starting. Kurt, we can hit it. You could start the YouTube thing. Okay. We are screening live our opening ceremony this morning via YouTube, so you can catch all of the proceedings afterwards as well. I'd like to welcome you on behalf of the School of Law and our organizing partners for today and tomorrow and the weekend, the South African University Law Clinics Association and the Commonwealth Legal Education Association. We are delighted to be celebrating today over 40 years of street law as part of clinical legal education and over 50 years of clinical legal education in South Africa, both of which were started by the founder of these movements, Professor David McCoy-Mason, who's with us on stage, who I think deserves an applause. I'd like to also acknowledge our dignitaries in the House. We are delighted to have our retired Chief Justice, Justice Sandile Ngcobo, with us today, who will be our keynote speaker. I have my Dean, Professor Freddie Mnyongani, the Dean and the head of the School of Law, who will be with us and giving an opening address. We have Mr. Davin Das, who is the president of the Commonwealth of the South African University Law Clinics Association, SAUCA. We bring apologies and greetings from Professor Mzukisi Njotini, who is the president of the South African Law Deans Association. He will be joining us a bit later, I understand. And I also would like to convey greetings from our Deputy Vice Chancellor for the College and the Head of College of Law and Management Studies, Professor Ernest Kgalema, who was also dragged into a meeting and is not able to be with us. Before I hand over to Professor Mnyongani to officially welcome you, I do need to ask certain people to stand up and greet you. These are members of the Conference Organizing Committee, the team of partners who've worked with me over the past 6 months, really doing formidable work to bring us all together. So we have Professor David McCoy-Mason, whose brilliant idea this was. We have Professor Fernaz Khan from the University of Johannesburg, but also a member of the Commonwealth Legal Education Alliance. We have Lindy Coetzee, who's the Deputy Dean of the Nelson Mandela University. Lindy's also the National Coordinator for Street Law, the movement in South Africa. We have Ms. Krishna Nicholson, who is the SG, Secretary General for SAUCA, and we have Mr. Eben van der Merwe, who is a clinical legal education expert. Other members will be joining us. On that note, I invite Prof. Mnyongani over to give us his welcome address. Thank you, Prof.
Thank you very much, Program Director, Dr. Janine Hicks. Good morning, ladies and gentlemen. Ladies and gentlemen, I stand on the protocol already established by Dr. Hicks and acknowledge each and every one of you here present. But in addition, I would like to acknowledge the presence of the former Chief Justice of the Republic of South Africa, Justice Sandile Ngcobo. I also want to acknowledge and recognize the father of street law and legal education in South Africa and an A-rated scholar, Professor David McCoy-Mason. Ladies and gentlemen, I'm also aware that we have esteemed guests hailing all the way from Zimbabwe, India, Malawi, Bangladesh, Ethiopia, Nigeria, Turkey, Croatia, Lesotho, Sri Lanka, Zambia, and from across the length and breadth of our republic, South Africa. Colleagues and ladies and gentlemen here present and also on a virtual platform, welcome. It is my singular honor and privilege to welcome you all to the School of Law at the University of KwaZulu-Natal. I extend a heartfelt gratitude to Dr. Janine Hicks and her team for their tireless efforts in attending to every detail that made today's gathering possible. Thank you, ma'am. This occasion is a special one as we mark the two significant milestones, namely the 40th anniversary of the first International Street Law Workshop and the 52nd anniversary of the Legal Aid Conference. Street law and clinical law education were never just modules or subjects. They were instruments of justice, platforms that opened the doors of law to communities who were otherwise excluded, particularly in South Africa during the dark days of apartheid. Clinical legal programs were introduced at a time when activism came at a great personal cost, when detention without trial was the norm, and when state brutality was at its peak. 40 years ago, South Africa was a terrible place to be in. We are reminded that in March 1985, police opened fire on a crowd, killing 35 people and injuring 27 others in what became known as the Langa Massacre. Just a few months later, in June 1985, community activists Fort Kalata, Matthew Goniwe, Sicelo Mhlauli, and Sparrow Mkhonto, who collectively were known as the Craddock Four, were abducted at the roadblock, brutally tortured, and murdered by security forces. In July 1985, the human rights lawyer Victoria Mxenge, who had only a few days ago addressed thousands of mourners at the funeral of the Craddock Four, was assassinated outside her home in Umlazi in front of her children. And of course, we know that she was the wife of Griffith Mxenge, himself murdered by the apartheid agents in 1981. These sacrifices remind us that the very foundations of clinical and street law in this country are rooted in the pursuit of justice, dignity, and freedom. It is therefore fitting that today we not only celebrate the progress made, but also honor the legacy of those who paid the ultimate price. We are especially honored to celebrate these milestones in the presence of Professor McQuaid Mason, a distinguished scholar who has worked tirelessly to advocate both street law and clinical legal education in South Africa and beyond. A man who has also made sure that our School of Law hosts an annual Mxenge lecture. Thank you for gracing us with your presence and for being a constant source of inspiration. We truly appreciate that, Prof. Ladies and gentlemen, this conference convenes at the time when the world faces complex and urgent challenges: social, legal, political, and environmental ones. Over the next few days, your program promises rich discussions and thought-provoking sessions that will no doubt contribute meaningfully to the advancement of justice and legal education. Time permitting, we also hope that you will have an opportunity to experience the beauty of Durban, the vibrancy of our culture, and the warmth of our hospitality. On behalf of the University of KwaZulu-Natal and the School of Law, I once again welcome you. May this conference be inspiring, impactful, and productive for all of us. With these few words, I declare this conference open, and thank you, MC.
Thanks, Prof. Nyongani. We need to excuse our dean. He's in a dean's forum this morning, actually, and he escaped to come and greet us, and he will pop back and join us soon thereafter. I now call upon our conference partners from CLEAR and from Saulka to provide their opening addresses. Professor Siva Kumar, who's the president of CLEAR and is traveling from India, will be with us later today. But Professor David McCoy-Mason, who, in addition to all the things that you've already heard about him, is also President Emeritus for CLEAR and will give the Professor Siva Kumar's welcome address on his behalf. Prof. David.
Thank you very much, colleagues and friends. As they used to say, all protocol observed. CJ, you understand that? Yes. All right. Here's the message then from, thank you. Here's the message from Professor Siva Kumar. Distinguished colleagues and friends, it gives me immense pleasure to welcome you all on behalf of the Commonwealth Legal Education Association, CLEAR, to this historic gathering that celebrates two remarkable milestones, the 40th anniversary of street law and over 50 years of clinical legal education. These are not merely anniversaries in numbers, but landmarks in our continuing struggle to reshape the teaching and practice of law as instruments for justice, equality, and empowerment. CLEAR has long believed that legal education must move beyond the classroom, engaging not only students, but also communities in ways that are meaningful and transformative. Both street law and clinical legal education embody this spirit. They demonstrate that the law is not an abstract doctrine confined to journals and courtrooms, but a living force that touches people's everyday realities, giving voice to the marginalized and equipping ordinary citizens with the tools to claim their rights. Our presence here today in Durban at the University of KwaZulu-Natal highlights our shared resolve to deepen that mission. This partnership between CLEAR and Saulka, together with the dedication of our colleagues at UKZN and SOLDA, reflects the vibrant network of educators, practitioners, and students who are united by one conviction, that the law must be a resource for social justice. This conference provides us with the space to exchange experiences across continents, to listen and learn from each other's innovative practices, and to chart fresh paths forward. My hope is that the conversations begun here will continue far beyond these sessions, shaping the next generation of legal educators and advocates for justice. I warmly welcome each of you and invite you to engage wholeheartedly in what promises to be a truly transformative event. Thank you, Professor Siva Kumar from India. Thank you. Okay, check my pen again. Thanks.
I invite then Davin Das, the president of SOLCA, to give his opening remarks.
Thank you. Before I go into the formal address, and I'm trying to encapsulate and embolden AI, I'm using my phone, and so that's my contribution to it. But I have to do two things. I think the first, whilst she's allowed members to stand and acknowledge the planning committee, I have to pay tribute to Dr. Hicks. Akin to Saulka's engine, who's Krishna, Dr. Hicks has been the engine of this conference. She's tirelessly worked behind the scenes. She's been behind us with a very good whip, but the passion and enthusiasm, I was inspired. So I want to say thank you, Dr. Hicks, to you and acknowledge you for this. Secondly, as I drove in, and I always believe, they say we stand on the shoulders of those who came before us. I recall that the last time I came to what is proverbially known to the UKZN individuals as the hut, and Dr. Holness would know it well, was with an individual, Skalk, who was known to many of us as he was. And I'm reminded of him, and I'm reminded of the contributions he used to make. And so I think of him as we engage in today's conference, and the last time we gathered, he was with us and no longer. So we just take cognizance of that. Clinical legal education, within the context of its politically charged and direct response to inequality through the provision of access to justice, the most marginalized members of society, has transcended a mere teaching method to a more epistemological innovation in transformative legal education. And note, Mr. Judge, I didn't use the word pedagogical. But for you, its rich pedagogy is quintessentially premised on the belief that law students learn best not only by studying theory, but essentially immersing themselves within the faculty-supervised practice of law, becoming completely involved and subsequently developing a fundamental understanding of law, being involved and immersed in it. Inspired by progressive law students and academics, and in some instances members from the profession, university-based law clinics such as UCT and WITS, had to be thrown in there, became essentially the sites of resistance, what essentially commenced as an access to justice project within the context of the pivotal Ford Foundation-sponsored conference at this very university, has now transcended into 24 university law clinics, limited not just to public universities, but private ones as well. They've become instrumental in the clinical pedagogy of clinical legal education and firmly institutionally entrenched within their curriculum and law schools, the component of experiential learning or clinical legal education. Coincidentally, we seem to return to a place which is perceived as the catalyst of what today is construed as this rich clinical methodology. More importantly, we see that there's this transformative notion of legal education, and your university law clinics have essentially shaped the legal landscape with groundbreaking legal cases brought by, for example, WITS and Stellenbosch University law clinics as well. Furthermore, Sahulka, in the establishment of advancing and promoting and supporting clinical law programs in 2018, has progressively brought together clinicians from around the country and produced the seminal law clinics and the clinical law movement, edited by our Professor Bodenstein. University law clinics have time and time again demonstrated their ability to innovatively and creatively navigate significant challenges, that of the hashtag fees must fall, as well as the COVID-19 pandemic. But despite these challenges, we've displayed the fluidity and agility in the continued provision of quality and professional access to justice, the effective teaching and training. Amidst the positive and progressive reflection, and being exceptionally mindful of both the international, regional, as well as domestic socio-political and economic parameters, we come together to contemplate, to engage, and to discuss matters based on university law clinic diminished funding, increased student numbers, appointment, retention, and promotion challenges, difficulties, and the like. And so in many instances, the very challenges that in some cases are threatening the sustainability of university law clinics, we need passion, energy, and this progressive cohesion brought together by clinicians to what I term be the next wave in clinical legal education. After all, clinical legal education is about shaping socially conscious and aware individuals. I am confident that as we come together to share our experiences and engage on our challenges, our collective efforts could very well be construed as the catalyst needed for this next generation. I thank you.
Thank you, Davin. Can I call Prof. McCoy-Mason to now come and introduce to us? We have a guest video message from Professor Penny Andrews from the New York Law School, and Prof. McCoy-Mason will introduce her to us before we play her video. Thank you. You found it?
Yeah. See if I
Good.
give a personal one. I think I can't find it. But hi, thanks everybody again. This will be a more personal introduction, I think, because Penny Andrews was our first legal full-time. We used to call the law clinic, was known as a legal aid clinic. And she was our first full-time legal aid secretary in those days. And Penny had just come out of quite a traumatic relationship, and she worked very hard, and immediately I saw that she had the potential to do something else. So I said, Penny, while you're working here, why don't you register part-time for a B.Proc degree, which was the old sort of undergraduate degree for law. And she did that, and she did very well. I said, okay, Penny, now you're going to do the LLB, the postgraduate one. And she did the postgraduate degree at the same time. She did that very well. I said, okay, Penny, now what you're going to do is we're going to send you overseas. You're going to get a scholarship, and we're going to let you go to an overseas American university, because that is going to help you develop. And she did that. She applied for a scholarship. She got a scholarship to do an LLM at Columbia University. She did very well. She ended up being one of their top students. And after that, we kept in contact all the time. I said, Penny, what are you going to do next? You've got this LLM. Would you like to teach? Where would you like to teach? I'd like to try Australia. All right, we'll try getting hold of La Trobe University. She did. She wrote her a good reference. She got there. She was appointed at La Trobe. She did extremely well at La Trobe University. She started getting very interested in gender issues as well. She taught in La Trobe for quite a while, and then eventually she decided she wanted to go back to New York because she had taught at Columbia, and she applied and ended up working at CUNY University, the City University of New York. And she did fantastically well there. She kept teaching there and enjoying herself. And then she thought, well, maybe I would need to move on a bit, and she saw a post being advertised for the Albany Law School in the state of New York. And again, I wrote her a reference amongst other people. And she ended up being Dean of the Law Faculty at Albany, University of Albany, in law school in New York. And then after that, I think she got sort of itchy feet. She wanted to come back to South Africa. So she then saw a UCT advertisement, and the University of Cape Town. She approached them. Again, we wrote references and things for her. And she got appointed as Dean at UCT. She had a bit of a harrowing time. She was also well known to the judiciary, Justice Norbo and others. Justice, should I tell her the story about when you went to New York in 1985? And Penny, he didn't have a TV or anything, so Penny donated her TV and radio to him as well. So there's a nice connection there between Justice Norbo and Penny. Anyway, Penny had a bit of a harrowing time because she was pushing a sort of a diversity program and a feminist program, and some of the older school guys weren't that happy. So eventually she decided after 2 years she would go back to New York. And at that stage then she was accepted at the New York School of Law, where she still is, and she runs a justice and a social justice program there. And that is what she's doing today. She unfortunately is going through health issues. You'll see that instead of having all her usual wavy hair, she's got a completely shaved head at the moment, and she's not shy to show everybody that she's actually got that. But it's with great pleasure that I now invite us to listen to a pre-recording from Penny. She couldn't come here and join us, but she's going through a lot of therapy at the moment. But with an open heart and great pleasure, I now introduce Penny Andrews to you, and you're going to see her in this pre-recorded recording. Thank you.
Good evening, everybody. I'm so sorry that I cannot join you in person, but I want to congratulate you, and particularly the team at the University of KwaZulu-Natal in Durban for putting together this really splendid conference. I'm thrilled to be able to talk a little bit about the Legal Aid Clinic, and particularly to talk about the beginnings when I was there in the mid-70s, specifically from 1977 onwards. At that particular time, we never thought that access to justice or even the idea of legal aid as being as transformative as it was. And nobody believed, I think, at that time that what Professor David McCoy-Mason had set in motion would be something that could be taken from Durban to other parts of South Africa and then globally. And I would say it's not an exaggeration to say that the Legal Aid Clinic and a street law afterwards, of which Professor McCoy-Mason obviously was the chief engineer, and I know that he recruited teams of really good people afterwards. Nobody believed that it would be as transformative as it has become. So I'm really, really pleased that you are celebrating this milestone at this time. The two things that I wanted to say was that we forget when the Legal Aid Clinic started in South Africa in the very dark days of apartheid, when law was really a force to suppress and oppress people. What Professor McCoy-Mason did at the University of Natal was not just to provide a service to people who were desperately in need of legal services, but also to educate students. Particularly since in 1977, the University of Natal was a white university. So it was really the first time that students had an opportunity to confront the face of apartheid through the lack of legal rights personally. And I think it probably, for many of them, I know for my classmates, once I started studying law at Natal, that this had a huge impact on their lives and on their practice in the law. So yes, I think that what was started 50 years ago, the Legal Aid Clinic, and then 40 years of street law, really ought to be applauded. And as I said, you are Professor McCoy-Mason. You've really you started a transformative movement which carries on. If it wasn't for the Legal Aid Clinic, I too would not have had the career that I've had. I studied for my arts degree, my BA degree, and then an LLB at the university. Because I am classified as coloured in South Africa, I had to apply to the Minister of Coloured Affairs for a permit to study at the university, and it was because of the kindness and support of Professor McCoy-Mason that I was able to do so. He also started me on a career in which my commitment to social justice was always very clear. I'm very fortunate that I've been in the academy for nearly 40 years, and I've taught in Australia, the United States, Canada, and many parts of Europe and South Africa too. I've been fortunate as well to be a president and dean at Albany Law School, which is in the capital of New York State, as well as dean at the University of Cape Town, and president of the Law and Society Association, a large scholarly association here in the United States. All of this would not have been possible if I did not become a secretary at the Legal Aid Clinic in 1977. So I'm truly, truly grateful. I'm grateful for my own life. I'm also grateful that the Legal Aid Clinic and the movement, as well as street law, has managed to persevere. And God knows we need so much more of it in our lives today. We're facing very, very difficult times here in the United States, South Africa, and elsewhere. So I wish you a very good conference. I hope your proceedings are not just thoughtful and deliberative, but also enjoyable, and that you all will be able to break bread and get to know each other in a way that you will remember. Thank you. Goodbye.
How inspiring. David, you're the golden thread that pulls all these people together. And on that note, can we invite you to come and introduce our our keynote address, Justice Ngcobo, also part of your spider web.
Thanks, Janine. I'm not going to observe any formalities now. I'm just going to introduce you to our guest speaker. And I must say, for me, it's always a great pleasure to see retired Chief Justice Sandile Ngcobo. He's been an inspiration, I think, to everyone. He's certainly, I would say, the most qualified of any of our Chief Justices when I tell you a little bit about his academic career and his experience. He graduated from the University of Zululand first, and he had two successors. We produced 3 Chief Justices. He was the first one, followed by Mogoeng, and then followed also by Ray Zondo. And all of them came from Zululand University first to the University of Natal. He did a B.Proc degree, and he already then got distinctions in constitutional law, mercantile law, and accounting. And then he came to us in Durban. He then went on and completed an orientation course in the United States legal system at Georgetown Law Center, where Ed O'Brien, who started the street law program, also happened to be. And he then went on to Harvard University and got an LLM from Harvard. And he concentrated on constitutional law, labor law, international legal practice, international human rights. And you'll see later that's what's permeated his appointments and his writings as well. He was, I think during your school years, you got a Barclays Bank scholarship, which again showed he had a lot of promise then. He was also, incidentally, in 1976, he ended up being detained for 6 months. So he actually, for a month, or 6, from September to April. But after that, he then went off and he worked, and again, this is why I say he's so qualified. He worked first in the magistrates' courts. So he knew what was going on in the magistrates' courts in Maphumulo, for instance. He then joined the law firm of KK Umtiyani. Now, KK, again, was one of our graduates. He also ended up in the Supreme Court of Appeal. Fantastic guy, one of our graduates as well. But he was running a law firm. And again, Justice Ngcobo at that time was an associate attorney. He did registered work. This also was good for him because he also got exposure to other forms as well. So he's registering companies, advising corporate directors, administering deceased estates, and conducting criminal and civil trials. So he got a very broad experience. In 1982, he went off to the Legal Resources Center, which had just been established then, I think. Was it? And I think it's now under Chris Nicholson, I remember. Yeah. And so he did that. And that, again, was a great experience for him and fantastic grounding for someone who's going to end up in our constitutional court as well. He dealt with public interest, civil and criminal cases. He did the ejection of tenants from townships, forced removal of black communities to the homelands, influx control, police torture and assault, wrongful detention, labor disputes, and eviction of squatters. So again, huge sort of public interest background to him as well. He also, at the time, argued in the Supreme Court, preparing pleadings and briefs, preparing cases for trial and on appeal. The unlawful transfer of teachers, cancellation of black pupils' matriculation results, cancellation of medical student scholarships. So he was laying a very practical foundation to all the things later that he was going to do when he got appointed to the bench. And then, and this was very key, I think, as well, from July 1986 to 87, he spent a year as a law clerk and research associate of the late Honourable Leon Higginbottom, who was a very well-known lawyer in the United States and eventually a former Chief Justice of the Court of Appeals. And so again, he was getting, this for me was key, he was actually getting exposure to how in a country which had a constitutional democracy, how lawyers operated then. So much so that when I as Dean required, when we got our interim constitution, I required that all our colleagues had to look at their courses and say, how is the new interim constitution going to affect my teaching of all these different courses? And I was able to get Justice Sandili to come along and tell him the American experience, that you can do these things. I didn't mention, this is a little footnote, I addressed a similar conference at UNISA about the need to change when we got a new constitution. And I remember one of the judges said he had never heard so much nonsense in all his life, just before the tea break, because we have a doctrine of precedent in this country, and you can't go along changing things with the constitution. So, and the organizer of the conference freaked out. I said, don't worry, guys, I'll talk to the judge at the tea break. I spoke to the judge and said, Judge, you know, you've heard of Canada? Yes, they've got a very good legal system. I said, yes. They've got a Bill of Rights, and their provisions are very similar to ours. The Canadian judges were able to adjust themselves, and I'm sure that you guys will be able to do it just as well as the Canadians. So he relaxed a bit. I then got up just in the conference. Okay, I've had a chat with the judge, and he agrees that he can do what the Canadians have done. So everybody relaxed, and the conference went on afterwards. But you can imagine that type of thing that does go on. So he did that. He then also helped teach a seminar. And this was interesting because the seminar he taught was Race Values in the American Legal Process at the University of Pennsylvania, Harvard Law School, and Stanford. Again, useful because as Dean, I'd introduced a course here on race legislation. So again, he was able to add strength to that course from us. Then August to November 87, he was a visiting foreign attorney at another firm, Pepper, Hamilton, and Sheets in Philadelphia, and he specialized in labor law. Again, an important grounding because you'll see he ended up in the labor law court as well. Beginning of 1988, he returned to South Africa and acted as the acting legal aid director for our clinic at the time, which was fantastic for us. And I don't know if that was because you had to cool off before being an attorney registered in South Africa and an advocate, because you being admitted, I think he came here during his, but it was fantastic to have him as a resource in the law school as well. And he taught a course on race legislation for us as well, which was perfect because he'd done it before. And then December 88 to November 89, he practiced as an advocate here. 89, he went back to the States to work with that Pepper firm again, and with a big firm of 300 lawyers specializing in labor, immigration law, again, something that was important for his return. 92, he returned, became an advocate, focusing on labor, employment law, constitutional law, general practice, and lecturing part-time in constitution. He loves lecturing. He still lectures occasionally at Maritzburg. I'd love to get him here occasionally if we need one to lecture for us as well, for our students here. From April 96 to the end of August that year, he was appointed as an acting judge, the Supreme Court of Cape of Good Hope Provincial Division. And then from January to 1996 to December, he was an ordinary court there. And then in 97, he was acting judge of the Labour Appeal Court, and then appointed as a judge there. So all this founding he had made him ideally qualified for the Labour Court. He was a member of the Industrial Court in 1993, coordinated our Equal Opportunities Project at our Centre for Socio-Legal Studies, and then in 1994 presided at the Independent Electoral Commission's Electoral Tribunal. That was interesting because Mandla Ngunu, who was our first full-time street law coordinator, was actually running the first democratic elections at the time. So another input from the University of KwaZulu, University of Natal at the time. And then he served as a member, chairperson, and member of the Rules Board for Courts of Law in February 1999. And then UCT made him honorary professor of law. Where's the dean? We should be making him an honorary professor of law here as well. He's published many different papers. You've got a whole list of them here. later on. I'm not going to read them all out, Sandile, but I want to let you speak for yourself. He's a trustee of the Dealer Foundation, a former trustee of our centre. And then 1999, 2009, President Mandela appointed him as a Justice of the Constitutional Court. And then eventually, under President Zuma, he was elevated to Chief Justice, which he served from 2009 to 11. You're married, I think, with a wife, Sandile. You've got 2 kids as well? 3 children. Okay, are they sitting in the audience? Okay, so I can't call you Sandile now. Retired Chief Justice Sandile Ngobo, please, it's my great pleasure, will you address the audience? Thank you.
Oops. How do you open this? Yeah. Okay. Good morning, everyone. With your permission, ma'am, may I stand on the existing protocol? There's just one thing that I do need to get out of the way. It's a confession. You know, since 2011, I have been enjoying a very quiet and a tranquil retirement until the invitation to come and speak here came. And most regrettably, some invitations are not really invitations, but they are summons. Summon to come and appear before this audience. And then suddenly, you're slowly being dragged back to work when in fact you retired. Professor Margaret Mason may remind you that I am retired. I don't have to come and teach here. But let me express my sincere gratitude to Professor David Margaret Mason for that very gracious and warm introduction. Professor Margaret Mason and I met in 1982, I think it was. Law students from the law clinic would come to the Legal Resources Center to bring to us some of the cases that they were working on, and we would help them navigate through the legal processes. But one of those cases involved pension, payment of old pension grants. To get a sense of what happens when elderly people go to these payout ponds to receive their pensions, myself and a couple of students went to these pay ponds. We arrived there around about 7 o'clock in the morning in the rural areas. But by the time we got there, the queue is just so long because people started queuing the day before. Now, having queued the day before, at about 10 o'clock, when you get to the window where you're supposed to get your money, you are told your money is not here, come back the next time. There is no explanation why your money is not there. There is no explanation as to what you're supposed to do. The two principles that the Law Clinic and ourselves establish. Firstly, when an elderly person makes an application for an old age, that person is entitled, as a matter of law, whether it's under apartheid or any system, to get a response. Either yes, you are entitled, or no, you are not. And if you are not entitled to a pension, you are entitled to reasons why you are not getting your pension. So those were the principles that the Law Clinic established through the efforts of Professor David Marquette Mason. And I should add, though, leave aside the story about the television and the radio that was given to me by Penny Andrews. Those students who came to us were under the supervision of Penny Andrews. That was not the end of his role in my life. Professor Marquette Mason persuaded me to go back to school, at least part-time, to complete my LLB, which I did. I'm deeply indebted to you, Professor Marquette Mason, for your guidance. Now, good morning, esteemed colleagues, teachers, students, and friends across the Commonwealth. It is a profound honor to open this gathering. And I would like to express my sincere gratitude to the Commonwealth Legal Education Association and the South African University Law Clinic Association for convening this conference, and to the University of Natal, KwaZulu-Natal now, I forgot the surname. KwaZulu-Natal is the only province that has a surname. Anyway, the university for hosting this event to mark two intertwined milestones, 40 years of the street law and more than 5 decades of clinical legal education. These are not merely anniversaries. They are testimonies to courage, perseverance, and creativity in the face of immense adversity. We meet today in a moment of both promising and perilous. It is promising because our constitutional architecture remains resilient, but it is perilous because the lived experience of too many still falls short of the Constitution's promise. This gathering, therefore, is both a celebration and a call to action, a call to make the Constitution work for all, not only in the courtrooms and the law reports, but in the daily lives of all the people of South Africa. I would like to begin my address this morning, as our Constitution insists we should, with human dignity. Not as an abstraction, but as the life of a child. It was an ordinary morning on the 20th of January 2014 at a lower primary school in Limpopo. A 5-year-old Michael Commomwealth asked to be excused from class in order to go and release himself. He walked to the toilet block, long neglected and dangerous. There was no seat to hold his small frame. When the brittle board gave way, Michael fell into the pit latrine and drowned. When Michael did not return, the search for him began. His mother rushed to school, breathless, praying that missing would soon become found. By the time they discovered him, his tiny hand was protruding above the filth, frozen in a final plea for help. The Supreme Court of Appeal would later describe his death as the most appalling and undignified. No judgment could bring him back. No amount of compensation could heal what was taken. But regrettably, Michael was neither the first nor the last to die in this manner. And the risk is not yet over, because in April this year, the South African Human Rights Commission found that at least 427 schools in the Eastern Cape still relied on pit latrines. These tragedies illustrate in the starkest terms what happens when the Constitution's guarantees remain aspirational. They are a reminder that our task as lawyers and teachers is not merely to interpret rights, but to make them real in people's lives. The question, therefore, before this conference is urgent and profound. How do we turn the vision of our Constitution into a lived reality for every child, for every student, for every community? And more pointedly, how do we ensure that no child ever again dies in a pit latrine, abandoned by the very system meant to protect them? This is not a legal challenge. It is a moral imperative. The Constitution offers both a vision and a toolkit, a society built on human dignity, the achievement of equality, the advancement of human rights, freedom, and justice. And it also offers accountability as a toolkit to realize its vision. As a nation, we are capable of realizing this vision, but we are in danger of not doing so. As the late Chief Justice Arthur Shaskalson observed, too many of us are concerned with what we can get from the new constitutional order, and very few are concerned with how to make the Constitution's promise a reality. The clinical legal education and the street law joyfully have not lost the energy and the resilience that once fueled the struggle for justice. Today they must rise again, drawing on the same energy and resilience to confront new forms of inequality, exclusion, and democratic deficit. They remain central to the Constitution's vision to be fulfilled. They can empower communities to demand safe school, monitor service delivery, and challenge systemic failures through education, advocacy, and litigation. Their proud legacy endures. Under apartheid, they reimagined law, not as an instrument of oppression, but as a force for justice. So the enduring question for this conference is this: what will we commit to today to make the Constitution work not just in the courtrooms and in the textbook, but in the daily lives of all the South Africans? The answer to this question will determine whether our celebration is merely symbolic or whether it marks the beginning of a renewed effort to fulfill the Constitution's vision. Let me turn to the proud legacy of these institutions. During apartheid, law was not a neutral instrument of order. It was a weapon of control. It dictated where African people could live, whom they could marry, which schools they could attend, and where and how they could work. For instance, the law was used to deport Africans from cities like Durban, which were deemed to be exclusive preserves of the white race. It's the cruelty of these laws and their perniciousness was captured by a High Court judge of this province, who describes Section 29 as a drastic in its general effect, foreign to the idea cherished by lawyers everywhere that the law's business is first and foremost to protect the liberties of the individual. I am reminded here of a case that was decided by the Appellate Division in the 1980s, I think it was, the highest court of the land at the time. There were two accused in that case. The one was white, the other one was black. Their only charge for which they stood trial and were convicted was that the white employer employed the black person as a supervisor, and that was unlawful. The highest court in the land confirmed that. It was in this context that law clinics emerged in the 1970s. Initially experimental and supported by foreign foundations, they quickly became spaces of resistance, where students and communities challenged injustice head on. In the 1980s, the street law took legal education beyond courtrooms and classrooms. They took it into the streets, into the schools, into community halls, making the law accessible and empowering. By the 1990s, South Africa's street law was a model that was emulated in a number of countries in Africa, Eastern Europe, and the Caribbean. All of this done under the leadership of Professor Marquette Mason. Thank you, sir. Together, the clinical education and street law help to build a culture of rights and a generation of justice-minded lawyers, laying the groundwork for the Constitution which we celebrate today and which is revered the world over. Their initiatives empowered communities to understand and claim their legal rights, instilled a service-oriented ethos among students, and helped to lay foundation of the rights culture, later enshrined in the Constitution. This is what we celebrate today. But the spirit of Michael Komape stands before us, reminding us with a painful clarity of the unfinished task that lies ahead. It reminds us that South Africa's constitutional democracy was born of a struggle, sacrifice, and a collective yearning for justice. It promised dignity, equality, freedom, and accountability, not as ideals, but as enforceable rights. It is a reminder that today the Constitution's promise is at risk. Institutions meant to deliver justice are faltering, and the gap between the constitutional promise and the lived reality continues to grow. Our task is clear. It is to close that gap, to make the Constitution real for everyone. But why is it that the Constitution's promise is at risk? The Constitution's promise is at risk because local government, the front line of service delivery, has collapsed into many of our towns and cities. One need only look at places such as Westbury in Gauteng, where people have gone out without water for weeks, while refuse piles up and electricity cuts deepen the despair. Budgets go unspent, yet households go without the basic needs that dignity demands. The failure of governance has sparked a wave of protest, often turning violent, as communities demand what they are constitutionally entitled. Recently, the President has acknowledged that budget meant for infrastructure too often go unspent, deepening service delivery failures and eroding public trust. When municipalities and provinces falter in planning and execution, essential projects stall and citizens' hopes fade. By strengthening management, building capacity, and committing to effective governance, we can restore confidence and deliver the dignity our communities deserve. Governance, however, is not the only failure. Our rule of law itself is under siege. Corruption is rampant. Corruption in this country does not only steal money, it also steals lives. The matters of whistleblowers like Jimmy Mohlala, Papita Degoran, Pamela Mabini, and recently Mpho Mafole show that in our country, telling the truth can be a death sentence. Each assassination is a crime against a person, but a wound to our democracy. Even justice institutions are compromised. The head of the National Prosecuting Authority has warned of infiltration by those intent on weakening it. The murder of the prosecutor, Tracy Brown, in July this year was not an isolated act, it was a pattern. When prosecutors must fear for their lives, accountability collapses, and the Constitution itself is imperiled. Recently, we've had some revelations by the Lieutenant General, the head of this province, about political interference in crime investigations. His revelations have led to the suspension of a Minister of Police, a senior prosecutor, and a senior police officer. These events confirm how deeply law enforcement has been captured and the urgency of restoring independence and the integrity. These challenges strike at the very heart of the Constitution's promise. And it is these challenges which frame the enduring question before this conference. How will we, together, turn that promise into reality? As you reflect on this question, may I urge you to draw inspiration from the preamble to our Constitution. It is a foundational framework outlining both our objectives and the means by which we may achieve them. Be reminded, every great journey begins with a map. Every great nation begins with a vision. For South Africa, that vision is found in the preamble of our Constitution. In just 156 words, it tells us who we are, what we value, and where we are going. Adopted by the people of South Africa, it affirms that the people, not parliament, not government, not the judges, the people are the ultimate guardians of the Constitution. And it declares that the Constitution is the supreme law. And what that means is everything and everyone is subject to the Constitution. But significantly, the preamble sets out 4 enduring objectives. The first is to heal the divisions of the past and build a society based on democratic values, social justice, and human rights. Secondly, to lay the foundation for a democratic country where government reflects the will of the people and every citizen is equally protected by the law. The third one is to improve the quality of life of all South Africans and to unlock the potential of every person. And lastly, to build a united, democratic South Africa that takes its rightful place among the nations of the world. These objectives embody the Constitution's vision. The preamble, therefore, is not just a preface. It is the foundation on which the text rests. As my colleague on the Constitutional Court once said, it reinforces, underlies all of the text that follows. Indeed, it is our moral compass. What the preamble does, it calls for a vision-based constitutionalism. This is an approach that insists that every judgment, every lesson, every legal strategy must serve the Constitution's founding values and the Constitution's objectives. For judges, it means the process of adjudication must reflect the Constitution's moral vision, not just the technical text. For educators and clinics, it means teaching the law as a tool for transformation and not just a set of rules. And for the people of South Africa, it means recognizing that the Constitution not only as a shield against abuse, but as a sword to bring about change through elections, oversight, litigation, protest, and participation. At the heart of our Constitution is accountability. It is the principle that breathes life into the Constitution and turns promise into reality. The Constitution is unique in that it creates a multi-layered accountability tool. The design of this scheme was deliberate. It was designed such that if one layer falters, other layers step in. The first one is the National Assembly, which stands as a cornerstone of democratic governance. It holds the vital mandate to hold all executive organs of state accountable and to exercise oversight over the National Executive Authority. Through its portfolio committees, the National Assembly wields powerful tools. It can summon any individual, demand documents, and rigorously question ministers, even the president. Cabinet members are constitutionally bound to report fully and regularly to Parliament. And when the executive fails in its constitutional duties, Parliament does not stand idle. It has the authority to act and act decisively. It does this by passing a vote of no confidence in the cabinet or in the president himself. It can even remove the president from office. This is not just a procedure. It is the pulse of a living democracy. Secondly, when Parliament and the president fail to uphold their constitutional duties, the judiciary, in particular the Constitutional Court, steps in as the guardian of accountability. It ensures that no branch of government stands above the law, and that the constitutional obligations are not merely aspirational, but they are enforceable. In the third place, we have Chapter 9 institutions, which are independent institutions to safeguard our democracy. These bodies serve as vital watchdogs, often becoming the first line of defense when parliamentary oversight falters. And their independence is not a luxury. It is a constitutional necessity, ensuring that accountability endures even when checks grow silent. In the case of the public protector, the Constitutional Court has confirmed that its recommendations are just not recommendations. They are binding and must be observed. Finally, we have the people. When all other safeguards falter, the people, armed with not only the power to litigate, but with the authority of the ballot, step in as the ultimate guardians of the Constitution. Through democratic elections, they hold the power to remove government that has failed them. This principle was established in the case of the United Democratic Movement versus the President of the Republic of South Africa, where the Constitutional Court reminded the disgruntled voters that their remedy comes at the end, at the time of the next election, when they decide how to cast their vote. The last national elections held on the 29th of May 2024 convincingly illustrates this principle. After 3 decades of commanding a majority at national level, the African National Congress saw its support reduced to 41%. This shift compelled the party to share with smaller parties a coalition government. This was a clear reminder that in a constitutional democracy, ultimate authority rests with the people. But there is another layer which is often overlooked, but very powerful. Clinical legal education, law clinics, and street law form a grassroots force for accountability. They can monitor Parliament, reinforce the work of oversight institutions, support strategic litigation, empower communities to stand and exercise their rights. They can make law tangible in a real people's lives. The question that should trouble us: how could Michael Gomambe die in a nation whose constitution promises dignity, equality, and the very means to hold government accountable? Why was this accountability toolkit not deployed to protect this young life? That is the challenge facing the street law, clinical legal education, the clinic. And this brings me back, finally, to the enduring question that I posed at the beginning. How do we transform the vision of our Constitution into a lived reality for everyone, for every child, for every student, and for every community? This is not a theoretical question. It is practical, it is deeply human. But as we reflect on this question, we must draw inspiration from Professor Amartya Sen, the Peace Nobel Prize winner. In particular, his conception of democracy as a government by discussion. We must remember that democracy is not just about elections. It is about public reasoning, dialogue, and accountability. Society plays a central role in shaping values and demanding transparency. Participation empowers individuals and enables communities to shape their own destinies. Clinical legal education and street law can transform the Constitution's vision into a lived reality through 3 of their mandates: educate, litigate, and innovate. Street law has, for decades, demystified the law for ordinary citizens, bringing constitutional literacy into classrooms, community halls, and workplaces. That work must be deepened. Clinical education in street law must teach not only what rights are, but how to use them. Communities should know how to demand reasons when services fail, lodge complaints with Chapter 9 institutions, access document under the Promotion of Access to Information Act. Remember, education is empowerment, and it is the first step towards accountability. Secondly, litigate. Clinics have led systemic litigation. We recall the Treatment Action Campaign case, where the court ordered the state to provide antiretroviral drugs. We recall Detroit versus the Minister of Welfare, where the rights of same-sex couples to adopt were vindicated. We recall the Stellenbosch University Law Clinic, which affirmed class action for exploited consumers. But going forward, law clinics must prioritize cases, focusing on cases that expose patterns of state failure, unsafe schools, irregular procurement, collapsing municipalities. And remember that each case is more than just a judgment. It is a structural intervention to bridge the democracy deficit. Thirdly, innovate. Beyond teaching and litigating, clinical legal education and street law must be innovative. They must develop new civic accountability tools. And here, I'm afraid you've got to be bold. You must consider, for example, specialized units such as oversight clinics and election and political finance units. In practice, many portfolio committees are weakened by party loyalty, where the majority parties shield ministers from robust questioning. Oversight clinics could step in and monitor Parliament, track unanswered questions, and mobilize citizens to attend these hearings. They can ensure that public participation is real, not rhetorical. By insisting that committee work must be transparent, they will pressurize MPs to fulfill their oversight role with integrity. Secondly, South Africa's democracy is fragile if the role of money in politics remains opaque. The Political Party Funding Act requires disclosure, but compliance is uneven and public awareness is low. Election and political finance units housed in law schools could monitor disclosures, track donations, educate voters about the financial interest shaping politics. Community justice metrics. These can measure dignity at grassroots. Is water flowing? Are budgets spent? Are schools safe? These innovations would not only complement existing institutions, they would compensate for their failures. When Parliament falters, Oversight Clinic can empower citizens. When transparency laws are under-enforced, finance units can fill the gap. When whistleblowers are silenced, clinics can keep the flames of the truth alive. Through education, litigation, innovation, clinics and street law can ensure that constitutional vision becomes practical, that accountability is not a theory, but a reality. Let me conclude by saying this. As we celebrate 40 years of the street law and more than 5 decades of clinical legal education, we honor a legacy that transformed the law into a force for justice, empowering communities, shaping lawyers, and laying the foundation for our democracy. Yet, the story of Michael Komape, the silenced whistleblowers, and countless others remind us that constitutional promises remain unfulfilled. Their suffering was not only a tragedy, it was a failure. The test of this conference lies in one question: how do we turn the Constitution's vision into a lived reality for every child, for every student, for every community? True democracy is not measured in statistics, but it is measured in dignity. Is the child safe at school? Is the grandmother heard at the clinic? Is the whistleblower protected? Clinical legal education and street law must ensure that the answer is always yes. They must do so by shining light on power, safeguarding democracy, and protecting courageous. Because if they do so, they can bridge the gap between promise and practice. The Constitution gives us vision. Our task is simple but profound: to act, to educate, innovate, and restore. Let history say of us, when institutions entrusted with the realization of the Constitution's vision faltered, we stood together and made the Constitution live in dignity, in justice, and in every life. Thank you. Oh, sorry. That's it. Okay, thank you.
Thank you so much. Justice Ngcobo, I wish I could apologize on behalf of Professor McCoy-Mason for having drawn you out from your tranquil retirement. But I assure you that for us it was a well-spent journey. Thank you so much. Davin and the Sulka colleagues, I'm sure it was important for you to hear your origin stories and be reminded of the importance of the work that you do, Dave, with the law clinics. But thank you, Justice Ngcobo. You have reminded us of the brief for our conference. We're not merely here to celebrate. The task and our theme of our conference is on examining that toolkit and the work of our clinical legal education through our law clinics and street law to continue that work of taking up that transformative tool for social justice. That project of dismantling systemic and embedded discrimination remains with us. And that task of ensuring delivery on rights and turning that constitutional promise into reality is now more vivid than ever before. I'm delighted to inform you, Justice, I am the new David McCoy Mason, by the way, can you tell? I am the street law coordinator and lecturer at the School of Law, and that legacy is alive and well. My street law students are working with Abahlali Basemjondolo, undertaking legal education and awareness, but preparing for strategic litigation on failures of water and sanitation delivery. We're working with Asiye Tafoleni and street traders on violation of rights by municipalities. We're in the Westville prison, we're in our schools, we've not forgotten our partners in schools. Our law clinic, under the leadership of Dr. Dave Holness, who's here with us today, is rising up to assist with refugee asylum seeking cases. We've been approached by the Land Court. We're going to be assisting with preparing bundles for litigation on the backlog of labor tenants' land claims. That work is vivid, and we're rising up to that challenge. I have to tell you, though, Justice, that only UKZN and under the guidance of Lindy Kotsia from Nelson Mandela University, we are the two only universities that still have street law as a core component of our LLB curriculum. Part of our work this week and our workshop this weekend is to showcase and model for other law schools the importance of keeping street law as a core component within the curriculum. We're going to be examining over the course of the next 2 days of conference and 2 days of workshops the role of street law and clinical legal education in addressing those failures and those challenges that you've spoken of. You have encouraged us and reminded us of the importance of this work. I'm call upon Lubabalo Mbambo, who's one of our graduate teaching associates and one of our student team that's assisted, to hand over to the three speakers a small gift from the School of Law in thanking you for your input this morning. Please join me in thanking our speakers. I call now on Professor Franaz Khan. We're doing a slight switcheroo on the program. We're going to take that item that we build for after tea to invite our colleague Chelsea Estries from LexisNexis, who are doing a handover on a rule of law project. It seems an appropriate moment. Surprise! Come and join us on stage, and then I will give you a short set of housekeeping announcements and a map for where we're going to be going thereafter, and we will break for tea. Franaz.
Thank you, Dr. Hicks. Good morning, colleagues, distinguished guests. I stand between your caffeine fix this morning. I promise it wouldn't be long. It gives me great pleasure this morning to welcome Mrs. Chelsea Estries, an accounts manager at LexisNexis. And Chelsea has been working very closely on an important initiative that truly speaks to the heart of access to justice. The Rule of Law Project is a collaborative effort between LexisNexis and our law clinics. The project developed a series of short, accessible videos designated to empower, or designed rather, to empower the clients of our clinics with basic legal knowledge on issues that directly affect their lives on a daily basis. The aim is simply to kind of bridge the gap between the law and ordinary members of the community, keeping them informed, protected, as well as better equipped when it comes to understanding the legal challenges that they face. So without further ado, I would like to introduce Chelsea that will share a bit more about the project. Thank you.
Good morning, everyone. It's both an honor and a privilege to stand before you today to introduce a project that lies at the very heart of who we are and what we stand for at LexisNexis South Africa. We are proud to announce the upcoming launch of our Rule of Law project, a bold and purposeful initiative that truly embodies our core mission, enhancing the potential of the African continent by advancing the rule of law. For over 85 years, LexisNexis South Africa has stood at the forefront of legal content and technology. We have evolved into a trusted provider of credible legal and regulatory information, offering intelligent digital platforms that empower our customers, from legal professionals to academics, to learn better, make informed decisions, and stay aligned with the latest legislative and regulatory developments. We pride ourselves on unmatched content accuracy, supported by superior technology. But beyond our commercial offerings, we are deeply committed to advancing the rule of law through meaningful, non-commercial initiatives, and the Rule of Law project is a shining example of that commitment. The Law Clinic video and leaflet project, developed in collaboration with the South African University Law Clinic Association, is designed to support and amplify the awareness work of university law clinics across the country. Through a series of short videos, graphic presentations, and informative leaflets, the initiative aims to empower the clients of these clinics, everyday South Africans, with basic legal knowledge on issues that directly affect their lives. The topics that are covered include family law, children's rights, and property rights, areas where legal understanding can make a profound difference. By making the law more transparent and accessible, we hope to promote equality under the law and enable individuals to participate more effectively in legal matters. These resources will help people identify when their rights may be at risk, take proactive steps to protect themselves, and seek appropriate legal remedies through their local law clinics. This project is a true collaboration. Volunteers from the university law clinics advise our LexisNexis volunteers to ensure the content is relevant and appropriately presented. Our technical team then brought this content to life, creating videos that clinics can use on their websites, in their offices, in awareness campaigns, and across social media platforms. This initiative complements our clinical law textbook, now in its 4th edition, written by clinic staff for law students working in these clinics. It's another testament to our ongoing support for legal education and community empowerment. In closing, I want to thank everyone who contributed to this project, from our academic partners to our internal teams. Together, we are not just creating content, we are creating impact. We are advancing the rule of law, one video, one leaflet, and one empowered citizen at a time. Thank you.
Colleagues, that's a timely reminder for us to acknowledge and thank our sponsors for this event, LexisNexis, Juta Publishing, and Oxford University Press. I encourage you in the rotunda, the round room that you walk through when you enter the building, the 3 publishers have displayed their clinical legal education materials and made those available to you. So please do join them and see the work that they have before them. Some brief housekeeping and announcements before we move to our tea break. We have set up Wi-Fi access in all the venues. The password is displayed on the wall, and you might wonder which network is it. It's the one that's in capital letters that says internet. So if you click that internet network, and there's the password displayed everywhere, there is an exclamation mark at the end, and you will have access to that. The other fabulous technology thing, what is the squiggly thing on your name tag? This, my friends, is a QR code. And apparently your phone, when you point at it with your camera, will recognize that. And where that will take you is to a digital version of our program. But importantly also, there is a link that says, click me, and that takes you to the booklet of abstracts. So when you are faced with the program and you wonder, which session should I go to after tea? We've lined up in the same order in which they appear an abstract for every single presentation that is before us. So photograph your QR code, it'll pull up the program for you. We've printed a copy, a hard copy, just for ease of reference, which you will find in your bag. But through the QR code, you can access the program digitally, and importantly, as I said, that book of abstracts. I have to tell you, there are 50 50 academic papers being presented over the next 2 days. And those abstracts are all set out in that online booklet for you to access so you can make your choice. Where will we be hearing all these fantastic programs and presentations? The program sets out the 4 parallel sessions where you will choose which session you want to be in. 2 of those venues are immediately as you step outside. So you will see room 1 is HC1, room 2 is HC2. HC stands for Howard College. So these venues are right here. Howard College 1 is directly opposite us here. Howard College 2 is just in the passageway out here. Room 3 you will take up to the moot court. Go back to the stairwell all the way up to the top, and that is the moot court. If you're opting to go to room 4, which is the school boardroom, you take the stairs up and you travel around through the law library and up a final flight of stairs to the school boardroom. There are posters displaying directions everywhere, but I also want to call upon our student team to show your green tags. You were met by wonderful students on your arrival. If you are lost and you don't know where to go, a student will pop up. They're about to walk in and wave to you. And please just ask a student, please show me where the boardroom is, and they will direct you. I want to acknowledge and welcome 4 of our student team leaders. We have Keith Zwairo. Keith, I saw you go to the back. He stepped out. Keith Zwairo, Lubabalo Mbambo, who you met on stage, Sabria Madi. There's Keith. Keith was the person emailing you over the last 6 weeks. Hi, Keith. Keith Zwairo, Lubabalo Mbambo, Sabria Madi, and Kiara Avatramani, who are coordinating our student teams. If you're lost and you need direction, these are our student teams with the green tag who can help you and show you where to go. If you're needing a restroom, we have sequestered the staff women's toilets. So the women's toilets are immediately outside. You will see there's a women's toilet sign. The men's toilet are immediately above the stairs on this next level, and we have a gender-free toilet on the same level as our staff lounge. One final announcement to make, and that is the silent auction. You were encouraged and in fact asked to bring with you a beautiful artifact or gift from your country that we could auction during the course of our conference to raise funds to cover the costs for our student participation. We waived registration fees for all our student presenters over the course of the conference and workshop. As you walk out the Howard College building, the theatre, on the right-hand side you will see 2 tables awaiting your artifact. We have a student there who will be staffing that table. How the auction will work, colleagues, is that over the next 2-day period, you will see beautiful and interesting artifacts displayed on the table. There is a sheet there. We encourage you to come and make a bid for that item. So you will fill in your name and you will state there 200 Rand, if that is the amount, or 50 Rand that you feel you would bid for that item. During the course of the next 2 days, please go out there and have a look and outbid. If you feel you could bid something higher than that, you will fill in your name and the amount that you would like to bid. And in our closing ceremony tomorrow at 3:30, we will then award the final top bidders their chosen artifact and take their money. So we encourage you, please, to display your artifact, come and visit the table, bid generously. Those contributions are going towards covering the costs of all our students who are attending and participating. We are now going to take a tea break. Our work begins at 11:15. If you have a look at the program, at 11:15 sharp, we will start with our breakaway sessions. We invite the facilitators and the presenters to make their way there a few minutes early. You heard how serious the task is before us. Our work begins at 11:15, and we will come back together again for our final plenary session at 4:30 this afternoon, for our final briefing for our movie this evening. Advocate Shafi Amir from probono.org has kindly arranged for us to attend a special screening of a Cannes Film Festival movie called Greytown Girl. But more on that later. Please join us for tea and coffee, 11:15 sharp, we're in our breakaway rooms to start working. Thank you, colleagues.